Anish, item 3, Judicial Appointments, Commission Bill 2022, report and final stages. Before we commence, I'd like to remind senators that a senator may speak only once at report stage, except the proposer of amendment who may reply to the discussion on the amendment itself. Also at report stage, each non-government amendment must be seconded. Amendment 1, Government Amendment, I move, arising out of committee proceedings 1, 3, 14, 15, 20 to 24 inclusive. 30 and 34 are related and may be discussed together by agreement. Is that agreed? Not agreed?
Those are agreed, but the rest of them are not agreed. We're
only on this amendment 1.
1, 3, 14, 15, 20 to 24 and 31 and 34. I'm agreeable to that.
Yeah, it's just the grouping of the discussion. The amendments will be put separately.
Yeah.
Okay. All right. Government Amendment, I move. Minister.
Thank you, Gahirlock. I move amendment number 1. Amendment number 1 is a government amendment proposes to be made to the long title of the bill. The amendment is a technical amendment for the purpose of inserting 2 commas on either side of the phrase "by the Commission," where it appears in line 13 on page 5. The amendment was one of a number of amendments to the long title suggested by Senator Barry Ward at committee stage. I've asked my officials to consider these suggestions in consultation with the Parliamentary Council, and out of that consideration arises amendment number 1, and I wish to acknowledge the Senator's eagle eye in this regard. In relation, I then move amendments 3, 14, 15, 20, 21, 22, 23, 24, 31 and 34 as well. On the 31st of January 2023, the Government made an order in exercise of the powers conferred on them by Section 6 of the Ministers and Secretaries Amendment Act of 1939. The name of the order in the Public Expenditure and Reform alteration of the name of the Department and title of Minister, Order 2023 SI number 19 of 2023. The order came into operation on the 1st of February 2023 and altered the title of the Minister for Public Expenditure and Reform to that of the Minister for Public Expenditure, National Development Plan Delivery and Reform. The Office of the Parliamentary Council has advised that a formal amendment is now required to be made to the bill in each case where the title of the Minister for Public Expenditure and Reform appears. The House will recall that I made reference to this matter at committee stage on the 7th of March and signalled my intention to bring forward amendments for this purpose. The title of the Minister for Public Expenditure and Reform appears 10 times in the bill, in 8 of its sections and in the schedule of the bill. Thank you, Gary.
Amendment 1 agreed. Agreed. Amendment 2 in the name of Senator McDougall, Boyhan, Keoghan, Crockwell and Clonan, arising out of committee proceedings 2, 26 and 28 are related and may be discussed together by agreement. Is that agreed?
Not agreed.
Not agreed. Discuss them individually?
Yes.
What's your proposing?
Is the proposal to discuss them individually?
Yes. I propose they be discussed individually.
Yes.
Just in terms of why would we discuss them? Why would we not discuss them together?
They're different topics.
Okay. All right. Is it agreed to discuss them individually?
Agreed.
Not agreed. The question is that the...
No, it's a matter for the chair to decide on the grouping.
Do you want to just...
Because they're related. They're grouped because they're related.
They are related, Senator, so it's up to yourself. Do you want to... They're your amendments if you want to discuss them individually. Like, I've never been asked to discuss them individually in terms of they're being grouped before, but if you wish to discuss them individually...
I think this is a matter of fundamental constitutional importance, and I'm not anxious to just abridge the debate by shoving everything together, having one speech and the like. No, I'm not prepared to do that. All
right, they're your amendments. We'll discuss them individually. Okay, Senator, Amendment 2. Are you moving? Seconded?
I moved that and Senator Boyhan is seconding it. This amendment has the purpose of removing from the long title of the bill words contained at lines 14 to 22 of the long title, and they are as follows. To provide for the aforementioned matters, having regard to the recommendations of the Council of Europe's Group of States Against Corruption, GRECO, that the system of selection, recommendation and promotion of judges target the appointment to the most qualified and suitable candidates in a transparent way. And having regard to the recommendation CM Record 2010-12 of the Committee of Ministers to Member States on Judges' Independence, Efficiency and Responsibility, adopted by the Council of Ministers on the 17th of November 2010 under Articles 15b of the Statute of the Council of Europe. And the words in question are in effect an attempt to introduce into the long title of this bill cover for cover on the basis of some reference to European law for the proposition that the terms of the Irish Constitution ought to be overridden in this particular way. Now, first of all, I think it's important to say at the very beginning that the Council of Europe's views are not an assistance in any sense to the interpretation of the Irish Constitution. They are opinions, and they're opinions given by a very diverse body which has many member states in it with many different forms of constitution and many different forms of judiciary. And when you actually look to the Greco document, to which I'll return in a moment, you can see that it is primarily aimed at ensuring standards of integrity, honesty, and eliminating any possibility for corruption in the judiciary. That's what Greco is about. And frankly, I regard it as an insult to the Irish judiciary that it should even be mentioned in the context of the appointment of Irish judges, that these measures are somehow required to eliminate risks of corruption, lack of integrity, and improper behaviour, improper standards on the part of the judiciary. There has never been in Ireland a case of corruption made out even in outline against a judge. Never, ever. There has been a case, in the case of Judge Brian Curtin, where I, as Minister for Justice, had to move a motion for his impeachment. But that was nothing to do with corruption. That was to do with a personal matter, an infringement of the criminal law which was alleged against him. But looking to now a century of judicial activity in Ireland, it has never, ever been suggested that any member of the Irish judiciary has acted corruptly. And yet now, in the long title of this bill, there's a reference to the Greco organisation, which is, I'll come back to its exact nature later, in the context of a need for reform of the way in which Irish judges are appointed. And I think that it's a shame that such a thing should be done. And I think it's only there to provide some kind of advertisement, perhaps, to the judiciary that these particular the provisions of this bill in relation to a commission were motivated by a desire on the part of the Irish state to comply with European standards in respect of the appointment of members of the judiciary. Now, it is notable, going to the recommendation which is referred to, that recommendation, Council of Ministers, record number 2010-12. It is notable that the document in question and the explanatory memorandum that goes with it is written in careful terms. And when it comes at chapter 4 of the memorandum, to the selection of judges, the status of judges. At paragraph 44, it says, decisions concerning the selection and career of judges should be based on objective criteria pre-established by law or by the competent authorities. Such decisions should be based on merit, having regard to the qualifications, skills and capacity required to adjudicate cases by applying the law while respecting human dignity. There should be no discrimination against judges or candidates for judicial office on any grounds such as sex, race, colour, language, religion, political or other opinion, national or social origin, association with a national minority, property, disability, birth, sexual orientation or other status. A requirement that a judge or a candidate for judicial office must be a national of the state concerned should not be considered discriminatory. And I halt there to say that it is interesting to note that Irish law makes no such provision. It doesn't require anybody being appointed to the Irish bench to be a citizen of Ireland. Paragraph 46, the explanatory memorandum goes on to say, the authority taking decision on the selection and career of judges should be independent of the executive and legislative powers. Now, that proposition is one which is an expression of opinion by a group of European ministers. But it flies directly in the face of what's provided in the Irish Constitution, which says that the selection of eligible persons to be judges is a matter for the executive, the government, to act on, advising the President. With a view to guaranteeing its independence, at least half the members of the authority should be judges chosen by their peers. And this effectively brings onto the stage the notion that the judiciary should have a key role in selecting themselves. Now, I'll stop at this point just to make this point. In Australia, in New Zealand, in Canada, in the United States, all of the great common law countries with written constitutions like ours, no provision whatsoever is made in any of those countries for the selection by judges of their own colleagues, or for the granting of a decision-making power in relation to who should be promoted within the judiciary in any of those states. The case was made here earlier on in the debate that somehow what we were doing was applying internationally accepted standards here. Insofar as we are a common law jurisdiction and we have a common law tradition, and the role of Irish judges is fundamentally different from the role of judges in the civil law countries, the majority of which are members of the Council of Europe. It should be clearly understood that at no point has any self-respecting common law jurisdiction with a written constitution ever stated that the judiciary should self-select in order to be free from the taint of being politically appointed. And there's a very good reason for that. We have a Supreme Court which now consists of potentially 9, but at the present 8 ordinary members and a Chief Justice. And that Supreme Court interprets for the Irish people what their constitution actually means. The constitution means what the Supreme Court says it means in the last analysis. And that court has huge powers in that it actually determines the nature of the fundamental law of this land and how it can be applied in any particular circumstance. Therefore, that court is one, the members of which have a radical potential effect on the development of Irish society. If someone is progressive, liberal, or radical in intent, or in temperament, or in approach to jurisprudential matters, and that person is appointed to the Supreme Court and joins a collegiate body, it is clearly pregnant with the possibility that his outlook or her outlook will determine the future characteristics of decisions of fundamental importance to citizens in relation to the interpretation of the Constitution. And in that context, the decision as to whether a liberal person or a conservative person, a radical, a progressive, an inventive person, or a person who is more inclined to be hidebound by previous decisions of the courts, a person who's notoriously pro-life or pro-choice, a person whose views about our relationship with the European Union should be one way or another, a person who is likely or more likely to take a view as to the extent to which the property rights provisions of the Constitution, or the family law provisions of the Constitution, or the education provisions of the Constitution should be interpreted in any particular way. It is obvious that such a person being appointed to the Supreme Court is not the same as everybody else. And the fallacy at the very heart of this bill is the banal, and I have to say slightly asinine, proposition that everybody should be appointed on the basis of merit. Because merit in this context doesn't mean anything to do with the issues that I've just raised. Is a pro-life person more or less meritorious than a pro-choice person? And is the fact that somebody is notoriously, for instance, pro-life or pro-choice, is that to be considered irrelevant, that there's some other measure of merit, which means that that becomes irrelevant in the decision as to whether that person should or should not be appointed to the Supreme Court? And that's the problem with this legislation, because it is giving to a commission of 4 judges and 4 laypersons effectively a role in determining which of the eligible judges of the superior courts should be in the Court of Appeal and should be on the Supreme Court and should become the presidents of those courts or the Chief Justice, as the case may be, which of them should be promoted, which of them should be left where they are in the courts where they are, where they've demonstrated conservative or liberal tendencies or whatever. It's giving to this new group, a commission, a choice which, on the face of the bill, is to be entirely determined by merit. But in circumstances where, and on this bill, on the debate of this bill, I have to go back to the debate on the previous bill when Minister Flanagan was reluctantly pushing that particular measure through this House. I asked, could the people interviewing or promoting somebody, could the 4 judges take issues such as the philosophy, the liberalism, the progressivism, and all of the other issues that I've just recently mentioned into account in determining what merit meant? And at least at that stage, it was agreed that they couldn't, that they were not there. These 4 judges are not there to impose their own view, say on pro-choice or pro-life matters, or on the meaning of the family in the Constitution, or family provisions in the Constitution. That was accepted then, but it's now being swept under the carpet. And we're now being asked to say that this body, which is reduced in size from the previous bill's proposal to 8 persons, 4 of whom are judges, 2 of whom are ex officio members, subject to standing aside when the court in question doesn't concern one of them, and 2 of whom are elected by the Judicial Council, that by the members of the Judicial Council, that we're now being asked to decide that that group is to determine the future complexion of the Irish Supreme Court. They have no mandate to do it. None of them have. The present President of the Court of Appeal, the present President of the High Court, they have no mandate to do this. They weren't appointed on the basis that they would come to a view about the desirability, yea or nay, of putting a Liberal or a Conservative onto the Supreme Court. They were appointed to hold judicial office, to be an impartial arbiter in litigation between citizens and between the citizens and the state. And although I know many of the people involved and likely to be involved, it seems to me that their outlook has nothing to do with the future composition of the Supreme Court. And I can go further. I can say, without breaching any cabinet confidentiality, that the outlook and philosophy of persons who were under consideration for appointment to the High Court and the Supreme Court — I wasn't there when the Court of Appeal was constituted — was something which was considered by those who made proposals at Cabinet for the selection of members of those courts. There can be no doubt about it. The Cabinet thought long and hard about who it actually wanted to appoint. And the Minister for Justice and the Attorney General were obliged by the Cabinet Handbook to consult with the Taoiseach and the leaders, the Taoiseach and the leaders of the parties in government in relation to such appointments. It wasn't a matter of the Minister for Justice, an office which I held, coming in one day and just slapping down a name on the Cabinet table and saying, I've got the agreement of the Taoiseach and that's what we're doing. It was always the right and the prerogative of the Cabinet to say, well, who is that person? And what do we know about that person? That applied to appointments to the High Court in the first place, and it applied to appointments to the Supreme Court. And for a certainty, the issue as to whether somebody was a social conservative or a social liberal was something which was carefully considered in making the proposal for their nomination to Cabinet, and discussed by the people who were required by the Cabinet Handbook to confer with each other before a proposal was made. And now we're saying, but the Cabinet will have no function in that anymore unless it considers that among the 3 people selected by the 4 judges for any particular appointment, it can detect a difference in outlook or philosophy or whatever at that late point. And what's more, it means that if, take an example, supposing there were 3 Conservative members of the Supreme Court, none of whose names appear in the shortlist, because the 4 judges have effectively left them off the list. the consequence is that none of them, if this bill is to be believed, can be appointed to the position of Chief Justice or promoted from some lower court to the Court of Appeal or to the Supreme Court. So it's not just simply a matter of making a recommendation and letting the government choose from a smorgasbord of judicial temperaments as to who the government wants, the direction the government wants the complexion of the Supreme Court to move. What we're actually doing is, in this legislation is the exact opposite. We're saying that a group of people in which the judiciary will have a blocking vote because of the way the whole thing is structured, will have the power to exclude any member of the judiciary from inclusion on a short list. And so we're actually saying that a choice which is now open to the government is to be cut back, and that people who the government might prefer to appoint for the reasons and on the bases that I've just mentioned will be actually withheld as potential appointees by the decision of some of their colleagues in the various courts. And I have to say, I think that that is radically wrong. And it's radically unconstitutional, because it isn't somehow infirm that the Cabinet of the day should determine the future direction and philosophical direction of the Supreme Court by the appointments it advises the President to make. There's nothing wrong with that. We seem to think that every decision that is made by the government behind the cloak of cabinet confidentiality is somehow infirm because it's not made in the open, and because the media can't see precisely what criteria the Cabinet took into account in deciding that one person should or should not be made Chief Justice or made a member of the Supreme Court or whatever. And there's, I believe, a retrograde and damaging undercurrent below the Greco considerations and across the European Council of Ministers, that somehow to have any discretion in the matter is to give to politicians something that they will abuse, whereas the Constitution does give them that discretion. Now, I did ask Minister Flanagan, could he give me one example of one question that could be asked at an interview of a candidate seeking promotion to the Supreme Court? Could he, for instance, say that whether it was legitimate or not for the interviewers to ask them questions about their fundamental philosophical outlook about the direction of the court before making the appointment? And he inclined to the view that they couldn't, that would be none of their business. And that was at a time when the body making the appointment was one in which the judiciary were a minority. But the principle doesn't change. Are the members of the Judicial Council entitled to take into consideration the general philosophical outlook of whether somebody is of the left or of the right, or known to be pro-choice or socially conservative or whatever it might be? Are they entitled to take that into account in compiling their shortlist? And this legislation in draft form strongly suggests that they aren't. That they can't, say, ask questions the drift of which would tend to suggest how, if appointed to the court, they would tend to use their judicial power as a member of that court in future issues. But that's the precise point that the government must have in mind when it makes an appointment. I mean, we have, for instance, at the moment, a housing crisis. And you see in the newspapers various commentators arguing that amendment of the Constitution is needed to, and a referendum should be held in order to help us deal with the housing crisis, the implication of which I think is that those commentators believe that the constitutional guarantees at the moment for property rights and for the constitutional recognition of the right of the Oireachtas to legislate for the common good, that all of those matters, those considerations, clearly will be affected if you inquire of a judge, directly or indirectly, where he or she stands on the issue, or a candidate for the judiciary, where he or she stands on broadly speaking, on how the property rights in the Constitution should be interpreted and applied. And anybody who says that this is a non-issue in the selection of the Supreme Court and possibly the Court of Appeal and possibly the High Court as well, misunderstands the constitutional function of our judiciary. We do not have a situation under any circumstance in which the government is obliged to be blind to the attitude and philosophy of a candidate for the judiciary. To take an example, I'm ineligible because of age, but if Deputy Richard Boyd Barrett and I were both eligible, he having done a bar degree and having practiced, and I being younger, of course it's of significance where he and I are perceived by a government to stand on issues to do with ideology, Marxist or otherwise. Of course it's a matter of significance. And I remember there was one person appointed in my time as Attorney General or Minister for Justice, I can't remember exactly when, but there was one person appointed to the English Supreme Court who was, not to the English Supreme Court, to the, I think it was to the House of Lords, but one senior judge in Britain, maybe it was the Court of Appeal, who was known to be a member in his youth of the Communist Party and to be, as a practicing barrister, an active Marxist. Now, how can anybody say that a government should not take that into account in determining whether that person should or should not be given senior office? It may be that the government might come to the view, oh, one Marxist out of 8 in the Supreme Court would be a good thing. But it might be a government might take the exact opposite view and say, no, I don't want that person being the swing vote on a divided court between different interpretations of the role of the state or the provisions of the Constitution. And the reason I say this is, you can have people who have radically different views who are both competent lawyers. And the particular person that I have in mind, I don't want to misname him, but he was clearly a competent lawyer. And his decisions seemed, to me as a lawyer reading his judgments, to be competent ones. But when it comes to what happens in Ireland, and that is that the fundamental meaning of the Constitution is determined by members of the Supreme Court, his presence or absence, or of somebody of his kin ideologically on the Supreme Court, is a matter of huge consequence. And therefore, the question arises in this legislation as to what criteria the Commission are supposed by statute to apply to the making up of their shortlists. And they're supposed to look to issues such as diversity. They're supposed to look to issues such as gender equality. They're supposed to look to issues such as capacity to speak the Irish language. They're supposed to look to issues which would make the judiciary more reflect the diversity of society as a whole. Those are statutory criteria which they're obliged to take into account. And then they're supposed to say, well, make the decision on merit after that. But how is a strong capitalist more or less meritorious than a strong socialist? And the answer to that question is very simple. Merit has nothing to do with it. Both of them could be perfectly intelligent people who got the same marks the whole way up through their exams and perfectly capable of deciding a personal injuries case in exactly the same way. But when it comes to the meaning of the Constitution, one of them is highly likely to go in one broad direction when considering decisions, and the other is likely to go in a diametrically opposite direction. And so, when you come to what the Council of Europe said, their recommendation must be read very, very carefully, because it says the following. However, at page 47 of the memorandum, however, where the constitutional or other legal provisions prescribe that the head of state, the government, or the legislative power takes decisions concerning the selection and career of judges, and that's people becoming judges in the first place and their subsequent promotion, an independent and competent authority drawn in substantial part from the judiciary without prejudice to the rules applicable to councils for the judiciary contained in Chapter 4, should be authorised to make recommendations, that's the first thing, or to express opinions, second thing, which the relevant appointing authority follows in practice. And that is the giveaway that there was clear recognition that the most that could be expected of an advisory body was that its views in practice would be followed, but not as a matter of law. And if the Cabinet gets 3 names before it for an appointment to the position of Chief Justice or ordinary member of the Supreme Court and does not like those three nominations for any of the reasons that I mentioned earlier, it must be that they are, in exceptional circumstances, free to say no, because it is their responsibility to make the appointment, and it is not, under our Constitution, the responsibility of anybody else. And the interesting thing about that as well is that the provision, the section, paragraph 47, mentions that the head of state, which would be the President, the government, or the legislative power, takes decisions. In some countries, you have to get legislative approval. In the United States, the President's nominations have to be approved by the Senate Judiciary Committee. But that's provided for in their Constitution. That's not something that the Senate dreamed up for itself one afternoon, or that the entire of the United States Congress decided, wouldn't this be a proper amendment to the American Constitution, to the appointment of judges in America, even though there's no mention of it in the Constitution. It's provided for in the Constitution that that's the way in which judges of the federal courts in the United States are appointed. And I go back to the point, no mention whatsoever is made in the American system of judges having any say, still less a veto, over the appointment of any of their number to any federal judicial position. The same applies in New Zealand. The same applies in Canada, where they have a written constitution, and in Australia. It's the government of Australia that advises the Governor-General, and the same in New Zealand, and I think the same in Canada, to appoint persons to their highest courts. So I have no problem with a Judicial Appointments Commission which would make recommendations or express opinions. That's fine. But it's an entirely different thing to say that their opinions effectively determine the constitutional power of the government to exercise its own discretion in these appointments. Now, we'll come on at a later stage to other amendments, so I don't want to trespass on them. But I do want to say this, that if 3 names are, as provided for in this bill, are somehow considered to be okay, why not 5 or why not 1? What rule of thumb, constitutional slide rule, says 3 is enough for the government to choose from, especially when the government is prohibited from choosing anybody who's not in the list? And effectively, we have to remember that the 4 judicial members of this body will know each other. 2 of them will be the President of the Court of Appeal and the President of the High Court will be in daily communication with each other. And whoever the other 2 may be, and the way things are stacking up because of the pyramidal shape of the judiciary, it's quite possible that you'll have a circuit court judge and a district court judge there. In effect, those 4 men or women will be in a position to say about anybody, in the first place, you may never become a judge, because we will not put you on a list, ever. And secondly, if you are a judge, you will go no further. And thirdly, if you are a judge in the superior courts, you will not be ever put onto the Court of Appeal or the Supreme Court. That's what we're actually providing for. And it is notable that Senator Ward said, which I'm amused his amendment has not been accepted, but it is notable that he said, well, what happens if the 4 judges go one way and the 4 lay people go the other way? What happens? And the answer is that the list cannot contradict the view of the four judges, because there's no casting vote. There's no way of deciding such an impasse. But much more important than that, the question is, what is the likely cohesion of the 4 lay members in terms of their knowledge of judges, in terms of their knowledge of the outlook of judges and the like? What's going to happen in relation to them? So I believe that there is nothing, and I want to put this on the record of the House, there is nothing in the Council of Europe document which authorises a national parliament to override its constitutional arrangements, and the statement which the relevant appointing authority follows in practice is carefully chosen language. It's not which the appointing authority must follow. It's not what it is legally bound to follow. It's clearly put there that the practice should be that you follow the advice from such a body. And there could be no constitutional objection if that kind of advice arrived on the Cabinet table. that in the end the government could say, well, we know the Supreme Court, we know that we have a good idea of the attitudes of the 3 people on this shortlist, and frankly, we don't want to appoint any of them to the position of Chief Justice. We would much prefer to select one of the other 5 members of the Supreme Court who were prohibited from appointing, because the bill claims the power for the Houses of the Oireachtas to prohibit the government from appointing somebody whose name doesn't appear in the shortlist. If the Council of Europe's carefully chosen language, which was that the relevant appointing authority follows in practice, which is clearly not a de jure obligation to follow it, but just is the expected norm, there could be no constitutional objection to this legislation. But we have gone way past that. And if they'd wanted to say which the relevant appointing authority must follow, they'd have said it. If that was their meaning, they'd have said it. So, citing this opinion as a reason for the Judicial Commission in its present form is misreading the document in question. And in any event, by any standard, the opinion of the Council of Ministers, no matter how firmly held or how universally held among Council of Europe ministers, cannot be something which authorises the abrogation of a constitutional discretion vested in our government. So, the reason, therefore, that I want these 2 references taken out of the long title is that they're window dressing. They're suggesting, in a slightly underhand way, that the mandatory exclusion of the power of the government to appoint eligible people to the office of Chief Justice or ordinary membership of the Supreme Court, which is contained later in this legislation, is somehow required or directed by a Council of Ministers decision. That's what those 2 references actually mean. And they aren't so required. I mean, I have no doubt that the practice would be to follow a recommendation. But on occasions, the government must be given the power to say, sorry, we're not doing that. We bear responsibility for this appointment, not you. We've watched you as a commission appoint, shortlist a lot of people and leave out a lot of people who we would have considered desirable appointees. And now we're saying to you, no, that group of 3 is not the best selection from the Supreme Court. We don't agree that we should be tied to making a selection from among them. And if it were the case that the Council of Europe actually said that the judiciary must always select themselves, and the government, no matter what's written in the member states' constitution, must always follow the judiciary's view on this matter, or the judiciary's view when attached to 4 laypersons' views. If that was the intention of the Council of Europe, they would have said it. What they merely ask for is that the practice should be to have regard for opinions and advice, recommendations and opinions. What we are doing in this legislation is going one unjustifiable step further and saying to the government that a practice which is there must be made mandatory. And you know, funnily enough, the Judicial Appointments Advisory Board, in respect of persons in the superior courts, it was never designed to give advice to the government in relation to these kind of appointments. In fact, in 1994, when Dermot Gleeson, one of our great attorneys general, drafted an act, he specifically provided that the Judicial Appointments Advisory Board should not trespass on the composition of the Supreme Court, in the sense that the only way in which their views on the Supreme Court could be relevant would be if somebody who wasn't a judge at all applied to them to be recommended for appointment. And there have been a few of them. Fairly few, but I mean there have been very distinguished judges who the cabinet of the day selected from outside the existing judiciary to include them as members of the Supreme Court. And those people were encouraged to apply to the Judicial Appointments Advisory Board and to be recommended by it. And that was, to use the phrase, the practice. And that's all the Council of Europe says. This should be the practice. But we are now saying it must be the rigid rule. And that cannot be right. So I think I've said enough in proposing the amendment.
Senator McDowell, Minister.
Thank you. Here, Amendment number 2 relates to the long title of the bill, and the long title of the bill gives a synopsis of what the bill proposes to do and what legislation it proposes to amend. The amendment proposes the deletion of an element of the long title of the bill referring to the recommendation of the Council of Europe's Group of States Against Corruption, otherwise known as GRECO, on a system of selection, recommendation and promotion of judges, and a recommendation of the Committee of Ministers to Member States on judges. These recommendations are reflected in the content of the bill, particularly in sections 47, 48, 51 and 52, which also reflect the engagement over a considerable period of time in consultations about the new procedures with both the European Commission in the context of its rule of law reports and GRECO in its review of Member States. A significant concern of the European institutions is the level of discretion a Member State government might have in relation to a body with an advisory or recommending function with respect to judicial appointments. The European Court of Justice in rulings has made it clear that an obligation under the rule of law, as it operates in the European Union, is the maintenance and enhancing of the impartiality and independence of the courts in the Member States. That court has taken the view that because national courts, such as our courts in Ireland, must implement and adjudicate on various fields of EU law, the process of appointment of judges to these courts must ensure the effective judicial protection of individual rights. I believe the measures in this bill will strengthen and enhance the procedures. We have to continue to safeguard the integrity of the judicial selection process in Ireland and the independence of the judiciary. The extent of discretion government will have, including the number of recommendations made, were prepared following careful legal consideration of the relevant Committee of the Ministers' recommendations and the emerging jurisprudence of the CJEU and of the Constitution. A power under the Constitution of the Government to appoint a person who is not recommended by an independent advisory body is not consistent with the requirements of the rule of law in the European Union, and the Minister has been advised to that effect, and the Government agrees with that position. Put another way, the possibility that the Government would appoint a person who was not recommended by an independent body would be contrary to the rule of law. The Minister has been advised that the provisions do not compromise or impede in any way the government power or in any way invalidate the executive function under the Constitution to advise the President on the appointment of judges, including in circumstances where only one or two persons can be recommended. This element of the long title has been included specifically in the line with the advices of the Attorney-General. Consequently, I am not in favour of the amendment. Thank you, Ciara.
Thank you, Minister. Senator McDowell, do you wish to come?
Well, I listened carefully to what the Minister has just said, and he's used the phrase contrary to the rule of law. What rule of law? The Commission of the European Union is not competent to determine the law of the European Union. It's not. It's not its function to do so. And even though they may have rows with the Polish state about amendments to the manner in which Polish judges hold their office and the tenure that is accorded to them, the simple fact is that the Commission of the European Union has no function in directing that the discretion of the Irish government under the Irish Constitution should be abrogated or diluted or confined in any way. It simply doesn't. No more than the Council of Europe's views on this matter are binding on the Irish state. But much more fundamental than that, when the Irish people adopted the various European treaties, no competence whatsoever was given to the institutions of the European Union to tell the Irish people that they must amend their constitution by a domestic law in order to comply with the Commission's view of what the rule of law actually entails. The Irish people never voted for the proposition that somebody in Brussels could tell them who could be appointed judges in Ireland. They never voted for that proposition. Ireland is a member state, and Ireland is only a member state to the extent that its constitution permits it to be a member state. And the European Union is not some superior body. It's a treaty organisation. Its court is a treaty tribunal, the Court of Justice of the European Union. It is not a European Supreme Court, and it is not entitled to abrogate or overturn provisions of the Irish Constitution unless and until the Irish people, by referendum, so decide. So, I mean, the mere fact that it may suit the European Commission in their ongoing spat with Poland and Hungary to take up positions about what they call and name the rule of law is irrelevant. The rule of law in Ireland is the Constitution subject to our EU obligations, not subject to desiderata developed by the Commission and views of opinion expressed by councils of ministers or even the European Parliament, for that matter, or European judges congregating together. They do not determine the nature or extent of the government's discretion in nominating Supreme Court judges. And as I wrote in the Irish Times recently, the effect of this legislation is as follows. And let's be very, very clear about it. It is that on the next occasion that there's a vacancy in the position of Chief Justice, if this commission is up and running and its statute hasn't been amended, which I hope it will be if it ever becomes law. But this group, the president of the Court of Appeal, the president of the High Court, 2 elected judges, most probably a circuit court judge and a district court judge, will come up with a list of 3 people out of the 8 or 9 ordinary members of the Supreme Court, which may or may not be all members of that court. There could be a High Court judge, or there could be a Court of Appeal judge. So it might be that, in effect, what the Irish government will be confronted with is a shortlist with only 1 judge of the Supreme Court on the list. That could be, I mean, certainly there is no reason why the bill should be otherwise interpreted. It is possible that only 1 member of the Supreme Court will be recommended. It's improbable, I suppose. Maybe 2, and maybe 1 from the Court of Appeal. But they're being told, in effect, that of the ordinary members of the Supreme Court eligible to be made Chief Justice, if it's 2, that 6 people who sit on that court day in, day out may not be appointed. That's what this bill means. And pretending, and I think it really is scandalous, pretending that European law somehow requires that to be the case, is bogus. No concept of the rule of law and documents being bandied about to keep President Duda and President Orban in check. No documents have the effect of saying that in Ireland henceforth it could be the case that of the 8 ordinary members of the Supreme Court, the government can only appoint 1 or 2 legally, that they will breach the law if they appoint any of the others. No document in Europe warrants such, whether it comes from the Council of Europe, the European Commission, and I don't trust the European Commission because they're more concerned with putting manners on the Poles and the Hungarians than they are with what we have had in this country, the longest continuing constitutional democracy in Europe, when a lot of them were all run by dictatorships of one kind or another. We have a judiciary which has always been free, independent, impartial, and it's always been done by operating the constitutional provisions under the 1922 Constitution or the 1937 Constitution by a government which is free to make its mind up on which person should get that job. And I mean, I look back over Chief Justices, and I know, for instance, it's well known, and since everybody concerned is now gone to meet their maker, that there was a time when the Jack Lynch government was concerned about the activism of the Supreme Court in constitutional matters. And 2 titans of that court, Judge Seamus Henchy and Judge Brian Walsh, were seen at the time to be very active in developing constitutional law. And the government at that time decided that it would appoint William O'Brien Fitzgerald, Billy Fitzgerald, to be Chief Justice. And the reason he was chosen was because the government wanted the court to take a more conservative line. Would he have been selected by this commission? No. Would the members of this commission be entitled to say, are we appointing a conservative or a radical? No. Can they ask any of the candidates to express their views as to how they'll decide future cases? No. But the government is entitled, in looking at all the people, to say, we do not think that that person has the same view of the development of the Constitution as we have. So it simply isn't, it's easy to come in here and produce a pat proposition such as that the rule of law in the European Union being directed against the Poles and the Hungarians somehow involves telling us that we can no longer appoint judges in the way we've done for a century now. And it is a century. But there is no provision of the European treaties which entitles the institutions of Europe to have such a view, or they can have the views they like, but to impose their views on other people. And the Irish people were never told, never ever told, that at any time, any treaty put before them for their approval in a referendum, that one of the consequences of doing so was that somebody would stand up in the Irish Oireachtas and say, the European concept of the rule of law no longer permits the government to elect or to select from among a majority of the Supreme Court a person to be Chief Justice, but could restrict them to 1, 2 or 3 persons, some of whom may or may not be members of that court. It's illogical, and it's fundamentally straining language beyond its fair use to say that somehow this is imposed on us from outside, or that the European Commission has a role in assessing our system or has found fault with our system. I mean, they may express views. They may think it's far, far better to have an independent, self-selecting judiciary. But unfortunately, the Irish people in 1937 chose a different way to select their judges. And there's nothing in the European treaties which elevates to a mandatory rule or requirement that Ireland must now abandon the system that has given us one of the best judiciaries in the European Union, one of the least corrupt, one of the most impartial, one of the most hard-working, superior court judiciaries of the European Union. And you see, the final point I make to you about Europe, show me anywhere in Europe where a single judge, man or woman, sitting in the four courts, can invalidate by a decision an act of Parliament or any act of the government by way of judicial review. Show me anywhere in Europe where that is permitted. Our judiciary are given a much more fundamental role and a much more active role than any other judges in the European Union. You can't walk into some Palais de Justice in Lyon or somewhere like that and say, I want an act of Parliament invalidated. There is a Conseil d'État, which is a different thing in France, which has a role in relation to proposals for legislation. But none of their systems allows one individual, man or woman, to hear both sides of an argument, hear the state, and say that bill is unconstitutional and void. None of them do. And that's because the adversarial common law system accredits full and original jurisdiction to High Court judges to determine the validity of laws having regard to the Constitution. Nowhere else is that available in Europe now. Even in England, it wasn't available. And, when you consider that, and when you consider the enormity of then coming into this chamber and saying that the Europeans want us to change the way we appoint our judges, then I have to say I feel a sense of shame.
Thank you, Senator McDowell. Before I ask Senator McDowell if he's pressing the amendment, have you anything to add, Minister Brown, to that? Okay. Senator McDowell, are you pressing the amendment? Amendment number 2. Okay. The question is that the amendment be made. Those in favour say tá.
Tá.
Those against say nil.
Yeah.
I think the question is defeated.
Vote all.
Vote all.
Division. Can I just welcome the students from the ATU, Atlantic Technical University in Sligo. Staff and students, you are very welcome to Leinster House today. Thank you for being here. Judicial Appointments Commission Bill 2022, report stage, Amendment 2 in the name of Senator Michael McDowell. The question is that the amendment be made, and on that question, a division has been challenged. Tellers Taw, Senator Michael McDowell, Senator Sharon Geoghegan, Neil, Senator Robbie Gallagher, Senator Joe Riley. The division will be conducted electronically. The voting interval is 1 minute, beginning now. Gurmagov. The question is defeated. Amendment number 3, Government Amendment I move arising on the committee already discussed with 1 that the amendment be made. That agreed? Agreed. We just wait for the Minister. Senator McDougall, Boyhan, Keoghan, Crockwell, Clunan, arising out of committee proceedings 4 and 6 are related, and 4 and 16 are related, and may be discussed together by agreement that the amendment be made. I'll ask Senator McDougall to move.
Move.
I second.
Senator McDougall to speak.
Amendment number 4 and Amendment 16 are related, and I propose to speak to both at this point. Firstly, the present proposal in the bill is that there should be a 9-member commission, and the proposal is that 4 of those members should be members of the judiciary, and 4 of the members should be lay persons selected in the manner provided for in the bill. The present wording of Section 9 says that the Commission shall consist of 9 members, subject to Section 45, being the Chief Justice, B, subject to subsection 2, the President of the Court of Appeal, C, 2 members of the Judicial Council appointed in accordance with Section 12, D, subject to subsection 3, the Attorney General, and 4 lay members appointed under Section 13. And then subsection 2 says that where the Commission is performing the function of selecting and recommending persons for appointment to judicial office in the High Court, Circuit Court or District Court, the President of the Court concerned, and not the President of the Court of Appeal, shall be the member for the purpose of performance of that function. The Attorney General shall not, as a member of the Commission, have a right to vote on any matter coming before the Commission for a vote, and 4, the Chief Justice shall be the chairperson of the Commission. Now, Senator Ward tabled an amendment to deal with the situation. What happens if this Commission divides 4-4 on any issue? And first of all, it's clear from subsection 3 that the bill in its current form proposes to have votes, and presumably to have a vote on the composition of a shortlist. So the Attorney General will be given no say if both sides are divided 4-4, or if the Commission divides 4-4 in any way on whether somebody should or should not be on the shortlist. The Attorney General is entitled, apparently, to discuss the matter with the other members, but he's not entitled to even resolve a 4-4 split between the members of the Commission where such a situation arises. And Senator Ward tabled an amendment to the effect that the chairperson should have a casting vote. Alternatively, if you get rid of subsection 3, the Attorney General, there would always be 9 voting members on the Commission, and you couldn't have a dead heat between the two sides, an impasse between the two sides on any issue. So, why are we creating a deliberately chosen deadlock? Why are we actually saying here is to be a 9-member commission of whom only 8 can vote, and where those 8 differ evenly as to any particular decision, the Commission can't decide it? No explanation has been given as to why any body whose function it is to make a recommendation should not be able, among its own members, when divided evenly on the issue, to have some mechanism for deciding which view should prevail. Now, just to give you an example of what we're dealing with here. We're dealing with, say there's unanimity on 2 members, 2 names to be included in the shortlist of 3, but 2 of the judges and 2 of the laypersons go for candidate A to be put onto the shortlist, and 2 of the judges and 2 of the lay members say, no, we want candidate B. And the Attorney General may or may not say, I think A is better than B, but he can't impose his will on either side. And the Commission then sits down and sort of stares at the blotter and says, what do we do about this? It must be the only case in recent history, recent legislative history, where the Oireachtas is being asked by the government to enact legislation designed to create situations where there's deadlock between the members of a body corporate in respect of one of their central functions. I can think of no other. I can think of absolutely no other case in any bill that I can call to mind at any rate, where the government has come before the House of the Oireachtas and said, let's create an institution where they can vote on the issue, but if they're evenly divided, they can't decide anything. I mean, that's an extraordinary situation. And it's ludicrous, to be honest with you. It doesn't bear any consideration in terms of arriving at decisions or whatever. I can't think of any body corporate ever established by a statute with an even number of people on it, where if there's a division, an even division of opinion on any matter, and the matter is put to a vote, the body can do nothing. But that's what we're being asked to approve here. Now, I think this is slightly more sinister than that. And I think it bears this construction, which is, to me, a rational construction, that the 4 judges will always be able to prevent anybody from being on a shortlist. And as I said earlier in my contribution on the last amendment, 2 of the judges, because they'll be elected by the Judicial Council, in which the great majority of members are circuit judges and district court judges, 2 of the judges will probably be a circuit court judge and a district court judge, a man and a woman, one of whom was a barrister when appointed and the other whom was a solicitor. But those 2, plus the president of the court to whom the appointment is being made, will, with the Chief Justice, or where the Chief Justice is not there, particularly if the Chief Justice has ceased to be a member of the Commission, has died, retired, or whatever it may be, the next senior member of the Supreme Court. I think it's the president of the court, who is the president of the Court of Appeal. Those 4 people between them are being given by this legislation the right to say, in respect of any person, you may not become a judge. And they're entitled to say that in respect of any judge, you are not going to go any further in the judiciary, and you're not going to be made president of any court because we will not put you on a list. And the 4 lay people can get blue in the face, and the Attorney General may say this is very unsatisfactory, but in fact the 4 judges will have a blocking vote if they act together in any particular case or in any particular decision. And the consequence of that, as I mentioned earlier, is that 4 judges are in effect being given the the right to prevent anybody becoming a judge, or and the right to dictate to the government as, who can and cannot be appointed to any position. Now, so what does the amendment in our name do? Well, first of all, it proposes to in paragraph D to take out the words subject to subsection 2. And subsection 2 says, when the Commission is performing the function of selecting and recommending persons for appointment to judicial office in the High Court, the Circuit Court or the District Court, the subsection 3 rather, the Attorney General shall not, as a member of a Commission, have a right to vote on any matter before the Commission for a vote. And we are saying, take out that exclusion on the right of the Attorney General to vote. There is one way of getting around the gridlock of 4-4 decision. And Senator Ward's amendment just simply gives the chairperson of the Commission, who is normally the Chief Justice, the right to a casting vote where there's a 4-all division of opinion. So that's the first thing that our amendment does. And I have not heard at any point or seen in print any attempted justification for this deadlock structure which has been advanced here. But as I said, the more, and a slightly sinister aspect is that it actually confers on the 4 judges a veto. There cannot be a shortlist unless they agree all the names in it. And that means that no matter what the government thinks in respect of any appointment, in all probability, a judge of the District Court, a judge of the Circuit Court, and one president of the relevant court and another will, between them, have the right to say, in respect of any other judge, you're not being promoted, you're not being made as a member of the judiciary in the first place, and you're not going to be president of the High Court, you're not going to be president of the Court of Appeal, and you're not going to be capable of being made Chief Justice. Now, is it fanciful to say this? Is it fanciful to make the point that there could be 4-4 divisions? Well, first of all, the Minister's section contemplates votes being dealt with in this matter. And in particular, the Attorney General is prohibited from exercising a vote, so it's very clear that there can be a vote. So we're then left with the situation that the 4 laypersons chosen in the way that the bill later provides are given a blocking vote themselves against the will of the judiciary. Now, the second thing that our amendment does is to delete 4 lay persons appointed under Section 13 and to substitute for 2 lay persons appointed under Section 13 and 2 persons, one of whom shall be a practising solicitor and one of whom shall be a practising barrister, nominated and appointed in accordance with the provisions of this part. Now, what's the point of that? The point of that is that at present the bill says that the one category of persons who can have no input into the composition of a shortlist, there's one group of people who can't have anything to do with it, and that is a practicing lawyer. You can be anything, that gets past the Public Appointments Commission. But the one thing you can't be is somebody who's actually seen the judiciary functioning day in, day out, and who's seen a circuit court judge, for instance, carrying on his functions and has come to a conclusion about his suitability for higher office, his capacity to deal with his work. People like that who actually in court and see these people working. They are the one category of people who the government has decided should have no input whatsoever to the selection or to the selection of names for a shortlist. And arguably, they are most likely to be the persons best in a position to express an opinion. A practicing solicitor or a practicing barrister sees people administering justice, sees how they do their job, sees how their temperament is in reality and not in a little curriculum vitae sent in to the commission. Knows that the person is fine to do simple stuff, but has huge difficulty with the complex stuff. They see that. They know that. That the judge has a short fuse, or that the judge is entirely amicable and decent to everyone, even perhaps to a fault. They know that. The Chief Justice doesn't know that. The Chief Justice has no idea, and he's chairman of this commission, what any individual a district judge is like. None whatsoever. He probably doesn't even know the names of most district judges. He might know the names of most circuit judges. But now the judiciary is expanding at such a rate that I can tell you, it's a bit of a mystery. And your eyes blink sometimes when you see the lists. You know, oh, I didn't know that she or he is now on the High Court. But, and this is the important point, there is one group of people who day in, day out have an appreciation of what it's like to be a judge, what it's like to be dealt with by a judge, how judges interact with the public, how they interact with the law, their degree of comprehension, their understanding of legal principles, their willingness to sit late, work hard, all of those things. The one group of people who have a clear view on that are the practitioners. And for some reason, between the bill whose ghost minister was Minister Ross, and this bill, that idea is dropped. The idea that people who are best in a position to have some input into the selection of a judge and best insight into the kind of person the judge actually is when administering justice, they are told not merely they're not members, but they may never be members of the Commission. There's something wrong in principle with allowing them to actually indicate their day-to-day, on-the-ground understanding of the suitability of a judge. The Minister is, like myself, a member of the Bar. And he knows what I'm talking about. He knows what it's like to sit before a circuit court judge. And he knows that he can form an opinion fairly quickly as to whether the judge is good, bad, or indifferent, are capable of being a High Court judge, or are capable of being a member of the Court of Appeal, being promoted or whatever. Now, I'm not saying that the Minister's view or my view is going to be infallible on these issues, but at least he'd be able to throw in his tuppence worth and say, as between these 3 or 5 remaining people looking for the last place in this shortlist, I can certainly tell you that candidate D should not be on that list. And the judges from the superior courts say, oh, why is that? And the minister, if he was there, could say, because I've seen him or her. I know how impatient the person is. I know how they rush to judgment. I know how they're prejudiced or whatever. I know their tendencies. And the High Court wouldn't suit them. It can certainly do that. But for some reason, this government has decided that those people can't have any input. And it's all the more mysterious because in the Judicial Appointments Advisory Board, there has been a representative of the bar and a representative of the solicitor's profession. I've served on that board myself as Attorney General. And I know from people who have served on it as representatives of the legal profession that they take their position very seriously, that they don't attempt to run their own horses in races for judicial appointment, but they do believe that it is their function to inform the other people who are going to make the recommendation under the existing advisory board system about the reputation and the perception of the candidate among those who see that person operating as a judge. So, as far as I'm concerned, it is an amazing slap in the face for legal practitioners to say we don't want you to have any hand, act or part in making that information available to a group of people who are selected on the basis that they are not legal practitioners and are very unlikely to have appeared before any of the people or been in court when any of those people have been sitting as a judge. I think it is a slap in the face for the legal profession, and it's unwarranted. Now, the Chamber may want to know why in paragraph 5 we provided that no person nominated or appointed under subsection 4 should be entitled to receive any remuneration or expenses under section 14. We had to do that in order to avoid being accused of putting something down on an amendment down which would have the effect of imposing a charge on the Exchequer. But I'm equally clear that the Bar Council nominee or the Law Society nominee would not be doing it for the money or for the expenses. They would be quite happy to do it out of the goodness of their heart and as a sense of, as part of their professional duty to the operation of the administration of justice. Now, so therefore, what are we dealing with here now? We're dealing with a body which has inbuilt paralysis. We're dealing with a body on which one member, though he can contribute to the discussion, can have no say, even in the case of a tie. We're dealing with the only body that the Irish legislature has, as far as I know, in the last 100 years, created as a body corporate with a voting function and no means of resolving a difference of opinion where the members are evenly divided. And we're doing all of that in the context of according to 4 judges, a veto over any other person becoming a judge or being promoted to any position within the judiciary. And that's what the Section 9 is intended to bring about. The amendment that was made to deprive the Attorney General of a vote was a deliberate act, because it was thought that he might be, in inverted commas, political. Even though he has to be consulted when the matter does come before Cabinet by the Minister for Justice, even on the shortlist under the Cabinet Handbook. But but the Attorney General is somebody who can watch the proceedings as a kind of a legal voyeur, but have no hand, act or part in the consummation of the decision-making process. I really do think, if anybody thought about this for long, they would say we will not deliberately create a situation where a body composed of even numbers has no casting vote, and one of its members who might have a vote may not vote, thereby creating this division. And we will not create a situation where 4 people can effectively block a name, even though the other 4 may not really be clued in as to why this is happening. And I, again, ask you to accept from me, this isn't just a matter of selecting a short list of 3 for recommendation. This is a matter of saying, in many cases, that the people not on that list may not serve in that position, and if they continue frequently and repeatedly not to be included on the list, can be excluded by these 4 members of the judiciary from any further development of their career. It's cronyism, and the funny thing is that it was Minister Ross who accused the legal profession of cronyism. He wrote a florid book which detailed how judges' children got married to each other and they invited their people to each other's weddings and all the rest of it, and he accused the whole system of cronyism. But I can't understand how, if 4 judges who are definitely more likely to know each other than the 4 lay people can have this veto, how you can say that this is a transparent or appropriate method of resolving a difference of opinion, a genuine difference of opinion between the members of the Commission, that to deprive them of a casting vote and to deprive the Attorney General even of a say where there is a split decision among the others, that is appropriate. And as I said before, I can't think of any reason why the Judicial Appointments Advisory Board regime, whereby the Law Society and the Bar Council were represented and diligently and faithfully and scrupulously advised the other members of the Commission of the, as far as they knew it, the reputation and the competence and the day-to-day suitability of a sitting member of the judiciary to be promoted or whatever, that they should be told, we don't want to hear your view. And it even goes further than that, I have to say, because if they actually were, if they heard that the dreadful Judge Michael McDougall was seeking a promotion, they can't even intervene to prevent it. They're told by this bill, you shouldn't write letters and you shouldn't start trying to influence the result. Or if they knew that there were 2 people in contention or 3 people in contention, and they said, 2 of them are substandard and one of them is the obvious person, they can't write letters to intervene, to say, you're in danger of barking up the wrong tree here. So all their knowledge is just cast into the wastepaper basket for no particular reason. And it isn't as if this is something which would be risky allowing them to have input, because the minister knows, and if he doesn't know, the Attorney General will tell him that the Judicial Appointment Advisory Board is hugely enhanced by the presence on it of a representative of the bar and a representative of the solicitor who can give that kind of information to the board. So those are the reasons which lie behind this amendment. It would make a far better bill if adopted. It would deal with the gridlock issue, which has been artificially created for the first time in Irish legislative history, denying anybody a casting vote and allowing for no means of resolving any division of even opinion between the parties on a body corporate. And in the circumstances, I have to recommend it to the House.
And Senator Paddy Burke.
Here, can I welcome the opportunity just to say a few words in relation to this amendment tabled by Senator McDowell. And I must say it was very interesting listening to Senator McDowell for the last number of minutes. And it would seem I'll be voting with the government, of course, for whatever the government decision is. I might be voting against my beliefs, but I'll be voting with the government. But at the same time, as I said, it was very interesting listening to Senator McDowell. And it would seem that it's very funny to have a corporate body with 9 members on it, one of which has no vote, and the other 8 can have stalemate and no way to resolve it. And I remember as a councillor for many years myself, where we'd be making various appointments to various boards from the local authority. And in Fine Gael we had a system where when you'd vote, whoever got the number 2s, that's whichever of them got the most number of 2s, that's how it was decided. Now, I don't know whether there's any provision for that in this case or not, or whether it's just a straight one vote of the 8 people, and in the event of a tie, how they're going to decide on what to do after that. So it seems to me that to be common sense gone out the window, and well illustrated by Senator McDowell. And you know, that's not just in relation to this. I think the whole public service, civil service, the way people are appointed now to the public appointments I think it leaves questions to be answered. And I was talking to a lady only in the last week where she tells me for the pre-selection, you fill out your form, you do an interview online, and it's fed into a computer then with algorithms on it. So that's how you're decided. That's how the pre-selection is done now. So the pre-selection is done with computers. So it doesn't matter how highly educated or how well you're fit for the job. Your fate lies in the computer. And as we all know, the computers are only as good as what's fed into them and how they are. What's the criteria that's put into the computer. And when you appeal, it would seem that you get, if you fail, and the decision of the appeal will be very vague, and you won't get any great detail as to what emphasis was put on the computer. Now, I know a number of people who have applied in the Public Appointments Commission, highly educated, with a lot of experience, and in my view would be way ahead of some of the people that were selected or pre-selected. But obviously the computer let them down for various reasons. Maybe they had a stammer, or maybe they had something, I don't know. But the computer let them down anyway. And in my view, I have seen over the years where people were appointed to ETB boards, teachers were appointed, VEC teachers, technical college teachers were appointed by boards. And of course, people were given out that there was favouritism and political influence and all of this sort of thing. But in the 30 years that I'm here, we've only seen once where there was a committee put in place to get rid of a judge. Only once. And that wasn't anything to do with his performance as a judge. It was something else besides that. And I haven't seen many bad teachers either that were selected by boards. I haven't. There's always people giving out about various things, but it's hard, in my view, to get away from the knowledge that people have built up on interview boards, and in my view, that's the way we should be for those Public Appointments Commission. And I do believe this, that the government of the day that's selected and elected, that they should not shirk the responsibility in electing people to top posts in the country, and that they take the consequences for the people they select or elect into those jobs. That's what they're put there for. They're put there to make those positions and make decisions on them. And I think this is a cop-out, to be quite honest with you. I don't agree with it, but I'd be voting for it. And the government, it's a government bill. I believe that the top jobs in this country, the government of the day, make the decision and they live with the consequences. And the people will deal with the government in 4 years after that, or 5 years, or whatever the term is. But I have to say that Senator McDowell, you make some very great points, and it was very interesting listening to you there in relation to this. And it would seem, I suppose the Minister will probably have an answer for us in relation to what happens when the stalemate arrives at, and someday, there's no doubt that it will arrive, 88. And so I'll leave it at that.
On Tara.
Thank you, Ciarán. I turn to amendment number 4, which is grouped with amendment number 16. And amendment number 4 seeks to amend section 9 by replacing it. And section 9 provides for the membership of the Commission, and it provides, in line with the government programme, that the Commission will be chaired by the Chief Justice. It provides for an equal number of lay members, 4, and judicial members, 4. Judicial membership comprises the Chief Justice, the President of the Court of Appeal, and 2 nominees of the Judicial Council. Section 12 provides for a more detailed prescription for the nominees of the Judicial Council. Lay members will be recommended by the Public Appointments Service, nominated under Section 13. The Attorney General is a non-voting member. The overall effect of Amendment number 4, while it does not change the overall number of Commission members, is to replace 2 lay members, 2 lay persons, on the Commission with 2 legal professionals. In doing so, the lay members are consigned to a minority position on the Commission. The Commission will be comprised of 4 judges, including the Chief Justice chairing, 2 legal profession representatives, the Attorney General, and just 2 lay members. That is 2 lay members out of a total of 9. That is interesting because when compared to the JAB arrangement, which has 3 lay members out of a membership of 11, the existing mechanism which we have set out to reform, it is a regressive step. The government could not accept this. The provision of the bill have been very carefully designed to provide a balance of membership on the Commission between the judicial members and lay members. Specifically, the amendment proposes that the Law Society of Ireland and the General Council of the Bar of Ireland shall each nominate a practitioner representative, and these will be a practising solicitor or a practising barrister along the lines of current JAB representation. These are to replace 2 of the lay members. The Minister decided that a representative of each of the solicitor's practising profession and the barrister's practising profession are not essential to the functioning of the Commission. Lay persons will come through a clear, transparent and expert nomination process operated by the Public Appointments Service, a tried and trusted process. All of the judges on the Commission will have been practising barristers and solicitors, as will have been the Attorney General. That is a significant background and current understanding of what applicants from the respective practitioner fees might bring to the role of judges. The bill copper fastens this applied knowledge by stipulating in section 12 that one of the Judicial Council nominees must have been a practising solicitor and one must have been a practising barrister. The amendment also removes the condition that the Attorney General would be a non-voting member. That provision is important in the context of the existing section 9. It would have the effect of putting the Attorney General in a position whereby his or her vote might be a casting vote. In the context, however, of the suggested amendment, it is just another vote being provided for and has no specific significance, given the way the amendment rearranges the membership and then minimises lay involvement. So I am not in favour of adding new legal practitioner nominees, reducing lay members, or providing the Attorney General with a vote, which is the global effect of the amendment, and I am therefore not in favour of the amendment. The bill, in all of its elements, including in particular those relating to the composition of the Commission, was drafted on the basis of careful legal consideration of the relevant Committee of Ministers, recommendations and their jurisprudence of the CJEU and of the Constitution. This is the case notably in its inclusion of a substantial number of judges and an equal number of laypersons along with the Attorney General. And this approach will serve to strongly underpin the independence of the judiciary. while Amendment number 16 is linked and provides in section 14, which deals with the terms and conditions of membership of the Commission, that the term of appointment of the nominated legal professionals whose membership is provided under the Senator's Amendment number 4 will be 3 years. For the reasons stated in my argument against replacing section 9 in the manner Senators propose, I cannot accept this consequential amendment either. Thank you, Ciarán.
Senator McDougall.
I'm interested about what the Minister has just said about the transparent and well-trusted method of appointing the lay members, because unfortunately his remarks do not reflect reality or the intention of the government. If you go to section 13 in respect of the proposed selection of lay members, you'll see that the Minister asked the Public Appointment Service to undertake a selection process. And then under subsection 2, it undertakes a selection process in accordance with the selection criteria. And what it does, it recommends to the Minister from among the persons who participated in the process, those persons whom it is satisfied are suitable for appointment as lay members. So if they get 50 people applying, they can come up with the 12 people who are suitable. Yeah, they could do that. They could come up with 12, and then they say to the Minister, and if you look then, you'll see in subsection 5, the Minister shall appoint lay members from among the persons recommended by the Public Appointment Service under subsection 2. So you now have a situation that the Minister, who's depriving the government of the right to choose its own people for the judiciary, is according to the Minister the right to select who, among all the people who've passed the test of suitability at the Public Appointments Commission stage, the Minister can choose the people he wants to be the lay members of the Commission. So this is a fascinating aspect of this legislation. We take the discretion away from the government and we give it to the Minister. We take the discretion to appoint people as judges away from the government, but the Minister is entrusted by the people who drafted this bill with the right to decide who among all of the suitable lay persons will actually get appointed. Now, why are we doing that? If it's so transparent and so independent, why does a political office holder decide who actually the lay persons will be? And there's an interesting little curlicue on that as well. Because if you go down to subsection 6, it says the Minister shall not make an appointment under subsection 5 unless a resolution approving the appointment has been passed by each House of the Oireachtas. So the lay persons' names will be brought along here and we'll have to decide, are we happy with the Minister's selection? This is an apolitical, and the same will happen in the Dáil. And wait for the little bonus cherry on top. It's subsection 9. A resolution referred to in subsection 6, that's the resolution of both Houses of the Oireachtas, shall not be required in respect of an appointment under subsection 8. And who are the subsection 8 appointees? The first cohort of people to be appointed as lay persons at the establishment day. So the government is going to be able to, without any scrutiny from the Houses of the Oireachtas, appoint all the lay persons prior to the establishment day on an entirely, the Minister alone can do it. So the first outing for this great commission of total transparency will be one where government appointees, government henchmen get all the jobs because they are the people who the government liked most among the lay people approved by the Commission, by the Public Appointments Commission. I mean, how rank hypocrisy can we have? That, you know, we have this claim, oh, these people will be entirely chosen above board. And yet, if 50 apply, 20 are approved as potential people, the Minister of the day has the right to look at the list of 20 and say, I'll choose 4. And he brings in a bill before the Houses of the Oireachtas and says, but of course, you'll all have a right to reject my choices, except for the first 3 years of the Commission, it'll be my cronies who operate this system alone. That's what this bill says. It'll be my choices, 4 choices who are on that Commission. Politically chosen people by a political appointee. You look at the 20 names or whatever it is that come through, and he'll say, those are the 4 people that Fine Gael or Fianna Fáil or the Greens or all 3 of them would really like out of that list. And they'll be the people. And the other members of the Oireachtas won't have any opportunity to comment on it because they'll be the first cohort of lay appointees. So far from being an apolitical system, you'll have a politically chosen by a politician. He will choose, or she will choose, from among a cohort of people, doubtless chosen apolitically. The Minister will be able to say, yes, OK, there's 10 or 12 people on the list before me, but I'm choosing the following 4. And because this is the first go of this Commission, nobody gets a right to veto me in either House of the Oireachtas. And we're told that is supposed to make a clean and clear, transparent system to prevent the government from using its own discretion. The Minister is given a discretion as to who he puts onto this Commission. That's what we're voting for. I mean, it's a shocker as they go. And the brazenness of, you know, the first Commission, we couldn't have a situation where the House of the Oireachtas would have any input into the first Commission. That'll be chosen in secret by the Minister from among the names. I mean, it's brazen. It really is brazen. I find it offensive to reason that particular subsection 9 comes in. Why can't you come and ask the members of the Oireachtas to approve your nominees in public in respect of the first 3 years of this Commission? And by the way, the people who are there in the first 3 years will be eligible for reappointment without having to go back to the Public Appointments Commission at all. So you could have 6 years of the Minister for Justice's nominees being the four people involved. That's what we're going for here. Eyes wide open. It's bad. It is really bad. And it shouldn't be permitted. Now, I mean, if they'd said that everybody appointed had to be approved by both Houses of the Oireachtas, fine, but at least that's going to be a political decision. Because, you know, the whips will be on that. It's not as if we'll all sit and the whips will be off and we'll be able to make a choice. That's not going to happen. It's going to be a party political, whip-driven choice as to who appears as the laypersons on this Commission. And it's going to be done in secret for the first Commission. And all of those people are going to be eligible for reappointment if the same Minister or his party is in office for the second time round. I don't think that that's worthy. And certainly, let's go back now to Greco and the Council of Ministers. And let's see, what does the Commission of the European Union think about that little arrangement? That there appears to be parliamentary scrutiny, but there isn't for the first outing. And that the Minister, a political person, appoints 4 appointees from a list. And the only sanction on him is that somehow his government supporters in both Houses of the Oireachtas might rebel and vote down his list. Vote down his list. That is not apolitical. It's blatantly political. I couldn't have thought of a better scheme myself when I was Minister for Justice for ensuring that my pals got on the bench than to do this. It's disgraceful. And the sanctimoniousness of the whole operation, that we're making this system much fairer and much more independent and much more impartial and much more in accordance with European standards. Are those European standards? That a party political Minister for Justice chooses from among a wide range of people his own appointees, and for the first commission can appoint them in secret, and thereafter uses the party whip to shove them through thereafter. And that's supposed to be an advance. And the Minister has the neck to come in here and say that appointing two practising barrister and a practising solicitor is diluting lay participation. So that these four people can be politically appointed instead. It's disgraceful.
I'm conscious that we're heading towards quarter after the hour of 5, which is when proposed. While you're in the House, we're going to adjourn debate on this part of the bill.
You're adjourning now, Ciarán?
It's as we're at quarter past 5. Time for this part. If you want to make an introductory remark, I'll let you do that. But
I can respond on the next day.
okay, Graham. So the question is that the House. No. Sorry, that this Judicial Appointments Commission bill stand adjourned. Agreed? No. Sorry. Sorry. Yes, thank you. Sorry.